Good morning, Simona. A very good morning to all the participants for the one-day national webinar on intellectual property rights. I request Principal M.V. Kodavi sir to welcome one and all.
Good morning, everybody. A respected resource person, invitees, staff, and my colleagues. It is indeed a pleasure to welcome you to this webinar organized by our college. The KLE Society Arts and Commerce College, Gadag, has a rich past and bright future. The college was established in the year 1985. We have completed more than 35 years of rewarding service in the field of higher education. Ours is an institution which offers a wide variety of conventional and need-based courses in the arts and commerce. With the evolving globalized scenario being found in deep-rooted culture of quality higher education, we have maintained an ambience that is ideally suited to the all-round development of students. Academic endeavors are pursued in a holistic manner to ensure that all the requisite and desirable inputs are provided to the learners. Further, all activities on and off the campus are oriented towards igniting the curiosity of the student and imbibing a culture of continuous learning. The highly qualified, dedicated, and enterprising staff lead, guide, and support the student community. The college is proud of organizing quality programs that are beneficial to all the stakeholders. In the present scenario, the online platform have helped all the stakeholders to engage and acquire the required skill and knowledge. The college has made the optimal utilization of the online platforms and has been succeed in organizing 15 webinars on different topics. Today, it is the 16th webinar. I, on behalf of the management, heartily welcome the resource person of the today's webinar, Professor Simon Wahid from KLE's Law College, Bangalore. I take this opportunity to welcome all the participants from different parts of the nation. I welcome all the organizing team and my staff for the webinar. Hope you will be benefited by the session. Have a wonderful day. Welcome one and all. Thank you. Thank you very much.
Yeah, I hope it was a very warm welcome. I, Sandhya Kulkarni, the coordinator of this webinar, take the privilege of introducing a very eminent resource person, Simona Wahid, a very young and energetic resource person from Bangalore's KLE Law College, and she is an associate professor. She completed her LLM in intellectual property rights from Hidayatul National Law College, Raipur, and she did her BA LLB honors from National Law University and Judicial Academy, Assam. She has conducted many workshops, a very young and a dynamic resource person we have amidst us, and she is one of the best teacher in the KLE Law College, Bengaluru. On behalf of one and all, I welcome Professor Simona Wahid. Simona?
Yeah. Hi, can you see me?
Yeah.
Okay. Thank you, ma'am, for that wonderful introduction. I'm really honored to be invited as a resource person for this webinar. And I hope I'll be able to do justice to what I'm about to speak about today.
Yeah.
So I was told that the majority of my audience are going to be non-law people. So,
Sorry to interrupt, Simona. A little volume,
yes,
can you just raise?
Okay. You want me to speak up?
Yeah.
Okay. Right. So the topic that I will be talking about is an introduction to intellectual property rights, and I will also be talking more in depth about how copyrights affect people who work in academia. Now, to do that, I will be using my screen share. So let me just try if that works. Share. Okay. Can you see my screen right now?
No, Simona.
Okay, I'm not sure how to do this. How do I start my screen share?
Is it on the desktop?
No, ma'am. It's on the app, the Google app. Have you made me the host yet?
You want me to make you host?
Yeah.
Yeah.
You have?
But she doesn't have it.
Can you see anything at all but my screen? No? Okay, I think I'll have to do that without sharing my screen. Anyway, so right, we'll start with what intellectual property rights are, and then we'll go on to copyrights and how it affects people in academia. Okay, so when we talk about IPR and intellectual excuse me, just 1 second.
Sorry for the inconvenience. I request Simona to continue.
Am I audible now?
Yeah, you can continue.
Okay, perfect. I'm sorry for the problems there. I was hoping to share my screen while I spoke, but since that's not going to be possible, I'm just going to try and do this without it. Okay, right. So I was telling about intellectual property and what intellectual property actually means. Now, when we say property, you obviously understand it to be something that you own. Okay, but the twist comes when we talk about intellectual property, because intellectual property is not something that you can see or hold in your hand. Unlike regular physical property, intellectual property is simply of the mind. Okay, it is something that you create out of your mind, and the right is given to the person who created something valuable from their mind. Okay, so basically, intellectual property, I can tell you a few types of them, which will help you understand what it is in a better context. So we can start by saying intellectual property is found in copyrights, it is found in patents, it's found in trademarks, in designs, in plant varieties, in traditional knowledge. Now, I've quoted quite a few of them, and I'm sure that you've probably not heard of a few of them, but I'm sure you've heard of patents, I'm sure you've heard of copyrights and trademarks. Let me tell you what copyright subsists in, what trademark subsists in, and what patent subsists in, so you can make a differentiation between these three types at least. To get a copyright, you have to create something like write a story, like draw something, or make a song, or shoot a movie. These are things in which you get a copyright. How is that different from a patent? You do not get a patent on any of these things that I told you right now. You get a patent on an invention. Okay, writing a story will not get you a copyright. Sorry, it will not get you a patent, it will get you a copyright. To get a patent, you have to have an invention. For example, let's say you have built a supercar. Okay, so this car is something that nobody has ever built or ever imagined. You're the first person who spent a lot of time and built a supercar. Okay, so what this patent is going to do, when we say patent, what patent is basically a right. It will give you the right to protect this new idea that you came up with. Okay, so therefore you get a kind of monopoly. We'll talk about that as well, the nature of IPR rights. Okay, now when we talk about trademarks are brand names. Okay, for example, if you take the brand name of Tata, okay, or let's say Nescafe, or any other brand that you can think of, Honda. These are brands that people thought about, put some thought into, and built a name, built a business around that name. And thereby, this is an intellectual property that we protect as trademarks. Now that I've given you a few types of IPRs, let me also tell you why we protect IPRs. Okay. There are two major theories of who we are protecting by giving intellectual property rights to people. The first person we are protecting is the creator. I told you that intellectual property rights are rights given to creators who create something useful from their minds. So first, what we're doing is we're protecting the creator by ensuring that when you have created something new, something useful for the society, you get protection to protect your ideas and your works so that nobody else can exploit it. And only you get the benefit of exploiting what you have created. What this does is it gives an incentive to people to create more of such knowledge. Okay. Now, that is what we do for protecting the creators. On the other hand, the people we are protecting is the society or the public at large as well. Okay. Because the ultimate purpose of creation of new knowledge, like I said, if you create a supercar, what is going to be the purpose of having created a supercar if you do not uh, enable others to use it? If you keep it to yourself and do not enable others to use it, there is no point of your invention. So the state protects your right over that supercar to a certain extent. In exchange that you give that knowledge to the state, and the state can utilize that knowledge for the furtherance of technology. In the same way, let's say you write a research paper. Now, since I'm talking mostly to people in academia, I'm assuming we're all writing research papers. So let's say you write a research paper and you've had a real breakthrough in what you have done research on. The fact that you have copyright over it, the state, the country, the nation grants you copyright over what you have originally created. Here, the reason that you are given this protection is because the state wants to give you incentive to write more research papers, do more research, but at the same time, I'm getting comments saying that it is not clear, ma'am. Sadhya, ma'am, could you confirm if my voice is audible?
No, your voice is audible. Continue.
Okay, okay.
It's clear.
Right,
It's
so
clear.
okay. So the reason that copyrights is given to you, what this essentially means is that once you've written your paper, you have certain rights as copyright. Okay. But at the same time, the state has to ensure that this breakthrough that you've done in your research reaches the public, because the ultimate objective is to ensure the progress of society. We cannot stop the progress of society when awarding you a copyright. Okay. Now, I would have actually really liked to share the screen, but I'm not able to do that. Anyway, okay, so without getting too technical, since again, I am assuming most of you are not from a law background, I would not like to get too technical with the legal language here. But at the same time, for your own understanding and research purposes, let me tell you, when we talk about a copyright and we talk about what you would get a copyright in, we're talking about Section 13 of the Copyright Act, which says that, which actually lays down the subject matter of copyright. Okay, I will not verbatim tell you what the whole section says, but let me break it down for you. Section 13 says that the subject matter of copyright is original literary art. Yes, ma'am.
Where have you saved your PPT?
It's on my PowerPoint app.
Okay.
The thing is, I wanted to share my screen, but there's I'm not able to do that.
No, you just open the PPT.
Mm-hmm.
And I have given you this one, share screen.
You have?
Yeah. You're not getting the option share screen?
I got it, but the options here are...
what is it showing?
Screen, photos, but when I press screen, it goes to recording. So... Anyway, I mean, I'll just continue.
Okay,
yeah,
okay,
I'll just continue without it. Okay, so Section 13 says that the subject matter of copyright exists in original literary, artistic, dramatic, musical works. Okay, so we remember it like this: literary L, dramatic D, musical M, and A, artistic. So these four things are very essential. When I say literary works, what I mean is, let's say you write a story, that is a literary work. If you write a research paper, that's a literary work. If you write a book, that's a literary work. But when I say literary work, it doesn't mean that it has to have a literary merit. If you write a poem which is rubbish and nobody likes it, you still have a copyright over your poem. Okay, it does not mean that it has to have some form of, some level of literary merit. But the thing is, anything which is written is a literary work. Secondly, we have dramatic works. Dramatic works are, to put it simply, they're plays. So Shakespeare's plays would be an example of a dramatic work. Okay, and dramatic works, how it's different from literary works is that it involves scenic arrangements. For instance, the narrator would portray a particular scene, which is not the same as literary works. So that is the difference between a literary work and a dramatic work. Then we have musical works, which are basically a tune or a melody that you write down in notations. If there are any musicians in the audience, I'm sure you'll understand that when you write down a tune or a particular melody, you have it in a sheet form. So that in itself is a musical work. And fourthly, we have artistic works. Artistic works can be various kinds. It can be photographs, it can be paintings, it can be drawings, it can be sketches, it can be a work of architecture, it can be your blueprints. All of these would constitute artistic works. Then we also have sound recordings and cinematograph films, which constitute parts of copyright works. Okay, cinematograph films, as you, I think, must have guessed by now, these are movies that you watch, or an advertisement that you see on TV, or sound recordings that we're talking about would be only the sound without the video. Okay, how this is different from musical works is that in musical works you don't have lyrics or words or any other things like that. It is simply a bare form of musical notation. But in sound recording, it would be a culmination of different kinds of music and lyrics and maybe different sounds as well. Okay, so those are the subject matter of copyright. Okay, literary, artistic, dramatic, musical works, and also cinematograph films and sound recordings. Now, when we're talking about copyrights in academia, I will keep bringing you back there. So what we're talking about is basically literary works, right? Okay. We're talking about literary works because I'm sure if most of you here have done your masters by now, and I'm assuming most of you have, then every person who has done your masters, I can guarantee you have your own copyright. Okay, because you wrote a dissertation, and a dissertation has to be an original work. So every person who has done a master's, I can safely assume that you have a copyright. And this is why you should know about copyright, because you have certain rights. When I say that you have a copyright, you have several rights under that copyright. Okay. Now, I said that to get a copyright, your work must be original. When I quoted section 13, I said that your work must be original. Extent that copied from others. Okay, it must originate from you. The author must have created something on their own, and it must be original. Now, the problem is when you're writing a research paper, I'm sure everybody understands that it's not possible to write something from scratch. When you do research, you read several articles, several books on the topic, and then you formulate your own ideas about what you're going to write in your research paper. So it is not possible that everything you write for your research paper is going to be 100% your own. You are definitely going to quote others. You're definitely going to bring in ideas from others. So ultimately, originality is not a very high degree that is being demanded. The originality that we're talking about under copyright is a minimum degree of originality that is required. Now, there are two doctrines. Again, I'm avoiding going into extreme legal terminologies. There are two doctrines which talk about originality and how original you have to be to get a copyright over your work. One is the doctrine of sweat of the brow, which says that if you have invested your labor, skill, and judgment into creating a work, then you have a copyright because your work is original. Okay. Let me tell you a very interesting case that happened in the University of London. The name of the case is University of London versus University Tutorial Press. In this case, what happened was, in the University of London, they have an expert panel which sits and sets question papers. I'm sure a lot of you have set your own question papers, so this should be interesting for you. So what they do is they have a panel of experts. They sit and create a question paper. Now, University Tutorial Press, the defendant, is somewhat like the guidebooks that you find in the market. The students refer to guidebooks. Now, what they do as part of their guidebooks is they publish previous year question papers in those guidebooks. That is a practice here as well. Now, University of London took offense at this and they said, you cannot do that. Our teachers have created the question papers. You cannot copy it because we have a copyright over the question papers. What the other party did, what University Tutorial Press did, was they said, you do not have originality in your question papers. You cannot get a copyright over them. You don't have originality because these questions are simply, these people have sat and they made these question papers based on the subject matter only. Whatever is being taught, it is not something new that they've created. So they claim that there is no originality in those question papers. But surprisingly, the court held that, this is a UK case, not an Indian case. The court held that because these teachers sat and invested sufficient amount of time, skill, labor, and judgment in creating those question papers, therefore, these question papers are original and therefore they should be protected by copyright. Now, that is a huge statement to make. This means that every person like us who sets a question paper has a copyright. But we know that we are not always quite as original with our question papers as we'd like to be. Okay. Now, the thing is that stance has shifted to quite an extent. This is a pretty old case that I'm quoting, but it is still quite relevant. Because in this case, they said question papers are works of copyright. But currently, the state of copyright is that you have to not simply put in labor, skill, and judgment, but also use a minimum level of creativity, which brings me to my second doctrine, which is the modicum of creativity. There has to be a minimum level of creativity in making those questions for you to be claiming that your work is original. So there is another case for that, and I will not go into it because it will take too long. But the gist of it is that simply making a question paper will not get you a copyright right now. You have to put in some amount of creativity from your side. Because, I mean, especially if you're people from arts and commerce background, let me give you an example of what a question paper there would look like. You teach the political theories, or let's say you teach about social contract theory, okay, in political science, and you ask a question saying, what does John Locke say about the state of nature under the social contract theory? That is not original enough. because you are simply stating a particular theory that is already in existence and you're asking about it. But if you can get really creative with your question, okay, and maybe make the student think in a completely different tangent, that could potentially be called an original work and could get you a copyright in the question paper. Okay, so that is all about originality. Now, let's say I told you you all have a copyright because you've written a dissertation. What exactly is the right that you have? What do you get when you get a copyright? There are two different sets of rights that you get under a copyright. Okay, the first set is called economic rights, and the second set is called moral rights. Okay, the economic rights you will find under section 14 of the Copyright Act, and the moral rights you will find under section 57 of the Copyright Act. Let me tell you what the economic rights are. The economic rights would include the rights such as the right of reproduction. Okay, let's assume you've written a book. Do you want to make 10 copies of that book? That is a right that is solely vested in the person who wrote the book. Okay. Another right that you have, the right of communicating to the public. You wrote a book, you got 10 copies printed. Do you give these 10 copies to the public? Do you sell it to somebody? Do you place it in a library? Do you give it away for free? These are decisions that only you can make as the owner of your copyright. Then you have the right of adaptation. So let's assume J.K. Rowling wrote Harry Potter. That is a work of literature, and she wrote a book and she got a copyright over that book. Now, whether that book gets made into a movie is something only J.K. Rowling can decide because she is the author of that book. Okay, so the movie is an adaptation of the book, and that is a right that is exclusively given to the author of the book. Another right that you have is the right of translation. Let's say you wrote a book in English, but you want that book to be translated into your state language. Who gets to do the translation? What language do you translate to? Again, these are all rights that you have, the owner of the copyright. Okay, now these I call them economic rights. Why I call them economic rights is because you can exploit these rights for your own economic benefit. When you decide to reproduce your research work, let's say, if your research work is really valuable and you decide how to reproduce it, so you have to give a license to somebody to print copies of your research work. And thereby, in giving that license, you can economically monopolize that area. You can say that I will give you the license, but for this much money. You get the bargaining power in that scenario, right? So again, let's say for translation, who you allow to be the translator puts you in a position of power. You get to decide who it is going to be. You get to come into an agreement with that person, and you get to, again, economically benefit from that scenario. And also to make an adaptation, I'm sure J.K. Rowling got paid a lot by Warner Brothers when they decided that they would make an adaptation of the movie. Oh, great. Somebody else can share their screen, but not me. That's weird. Okay. Anyway, right. So those were your economic rights. Moving on to your moral rights. Okay. This you will find under section 57. When I talk about moral rights, they're not moral in the sense what you study about in moral science. Oh, this is immoral. No. These actually are rights which are not economical, but are inherent to the personality of an author. Okay, and there are two basic rights that you will find under your moral rights as an author of a work. The first is the right to paternity. By paternity, I think you understand that I mean something like a father. When you write something, when you draw something, whatever you have drawn, whatever work you have created, you are the father of your work. Okay, you have created that work, and therefore you have the right of a father, which is basically the right to be attributed. Okay, the Mona Lisa was painted by Leonardo da Vinci. Now, whenever I show the portrait of Mona Lisa, I must always acknowledge that it has been painted by Leonardo da Vinci. Okay, not doing that is violating the moral right of Leonardo da Vinci. I hope that part is clear, because what happens is, this is very important for research, is because we tend to quote others in our research papers. And sometimes some people do not cite the source of where they got that information from, right? You must always ensure that you put a footnote at least and cite the source of where you got a particular statement from. It is just in, I mean, it is common courtesy, but it is also the violation of a moral right. Okay, so your first moral right is your right of paternity. The second is the right of integrity. Okay, what the right of integrity means is that when I create a work of copyright, and let's say I give it to you, let me again give you the example of how the right of integrity got violated once. And this is the case of Amarnath Sehgal versus Union of India. What happened here was, so there is a famous sculptor, and he was given a job by the National Science Vigyan Bhavan, sorry, the Vigyan Bhavan in New Delhi. So the government of India basically gave him a job to make a mural to be placed in the lobby when you enter Vigyan Bhavan. They wanted a sculpture. So he worked on it for quite some time, and he made a beautiful sculpture. But now again, copyright works in strange ways. Okay, I mean, I've not gone into the details. When the government gives you a commission to make a work of copyright, they essentially take away the copyright from you. So basically, they're giving you a lot of money, but they're saying that the economic benefits will stay with us. But even in that situation, you still have your moral rights. Okay, so what happens in this situation is, he made a sculpture, but he gave up his economic rights to the government. The government kept the sculpture there for like 10 years or so, and then they got bored of it, and they transferred the sculpture to a go down. And in the process of transferring it, certain parts of it chipped away, and it was, kept in a very bad place in a go down. Later, Amarnath Sehgal visits that place. He sees his mural is not there. He inquires about it, and he's told that his mural is dumped somewhere in the go down. He is not at all happy about this, and he decides to write to the government of India saying, my work is being treated so badly, and it's not nice at all. It's not nice of you. Please restore the mural and the sculpture to its original position. The government does not respond to him. So therefore, he goes to court with this, and he tries to um, enforce his moral right of integrity. So, moral right of integrity says that even when you've given up your copyright, someone else cannot mutilate, deform, or destroy the original content of what your copyright work was. Okay, so what happened in this situation was, his work was mutilated because it chipped away, it was kept in a bad place, it was almost deformed. And to give you an idea of the gravity of the situation, he won the case, and the amount he won simply for the enforcement of his right of integrity was a sum of 50 lakhs. The government was made to pay 50 lakhs to him for violating his right of integrity. So imagine how much your economic rights are worth. Okay. Now that we've covered what the economic and moral rights are, and I've told you that these are the rights that you have as an author. Okay. But at the same time, you have to place yourself on the opposite side of the spectrum. You have to place yourself in a situation where somebody else is an author, and you have to consider whether you are infringing their rights. Okay, in copyright, we call the violation of economic or moral rights as infringement. Okay, so you have to consider, am I infringing somebody somebody else's copyright? Okay, so how could you do that? What are the ways in which you can infringe somebody's copyright? You go back to the economic rights that we talked about, the right of reproduction. I told you that nobody but the author can give authorization or even choose to reproduce. Are you reproducing somebody else's work of copyright? I know most of you will say no, but think about it. Have there been times when you took a book from a library, went and photocopied it? That is a reproduction of a copyright work. Okay, have there been times when you took a book and took a photo of a particular page? What you're doing is you are copying somebody else's work, and you are violating the right of reproduction that belongs to somebody else. Okay, again, the right to communicate to the public. Let's say you take 10 photocopies of a particular book and you give it to several of your colleagues. You are communicating somebody else's copyright work to the public. That is an infringement of copyright. Okay, but not to worry. The best case scenario in this situation is that we are people who belong to academia. And there are several exceptions under the copyright law for people like us. Remember, I told you that the goal of copyright law and intellectual property law in general is the advancement of society through dissemination of knowledge and technology. So when a particular book is written and you need to study from that book, if it's an academic book, okay, it is a textbook that has been prescribed, then the Copyright Act gives us certain exemptions. Okay, for this, you could choose to refer to Section 52, which talks about fair dealing of copyright. Section 51 will talk about infringement. I told you how you can infringe a copyright. And right after that, you have Section 52, which says certain acts which might look like infringement, but are actually fair uses. Fair uses meaning that it is allowed by the statute because it falls within certain limitations or purposes. Broadly, fair use would consist of any uses ranging from criticism or review, um, private or personal study, research, and education. Okay, and quite conveniently, all our uses usually fall within educational purposes, research, criticism, or instruction, right? So essentially what is happening is, if a particular use in which you have reproduced somebody's copyright without their permission falls within an educational use, then it does not amount to an infringement. Okay, so what is happening here is, imagine a student who writes an answer which is verbatim a copy of what he has read in his textbook, because students are quite good at memorizing, I found. So what they do is they memorize the entire textbook and they reproduce it as it is on an answer sheet. So this would have amounted to copyright infringement because they're completely verbatim copying somebody else's work. But this is uh, I wouldn't call it an exception. The fair use is a rule. Okay, so it is excluded from the purview of what an infringement of copyright can be. So the fact that a student writes his answer from a textbook does not amount to infringement of copyright. Even when setting a question paper, if you take a substantial amount of words from a particular book, that also does not amount to infringement of copyright. So let's say again, I'll take the same example of political theory where you talk about the state of nature propounded by John Locke, and you make a statement that John Locke had made. that does not amount to copyright infringement because it is for an academic or educational purpose. Now, for teachers who are taking online classes, okay, I'm sure this will make a lot of sense to you because when when you're taking online classes, you're making PPTs, you're sharing, pictures, so on and so forth. Now, let's say you download a picture from the internet. Okay, let me warn you: any picture you download from the internet also is probably a work of copyright of somebody else. Anybody who has taken a photo is the owner of the particular photograph, right? He has a copyright over his photograph. So I would suggest you be careful when you download random pictures, but also remember that as a teacher, you are protected because you are using that photo for an educational purpose. That would not amount to an infringement. But if at the same time you use that picture in a presentation where, let's say, you are making a pitch to an investor for a business idea, what you're doing is you're commercially exploiting somebody else's picture. Now that would be an infringement. Okay. Again, now another perspective that I would like to stress upon a little bit is, and maybe people should even also think about it, is we have several prescribed textbooks that we study from for a particular course. And there are guidebooks which take up the necessary excerpts of all of these books and make one book. Let me tell you, that is a clear violation of Copyright Act. Because what you're doing is you are competing with the economic rights of the actual author of those books, right? You are what you're basically doing is, a student would not be inclined to buy those books, those prescribed textbooks, because he thinks I can get the main gist of it already from a guidebook. What this does, again, if you think deeply about it, what this does is it discourages the authors who wrote the original books. If nobody is going to buy their books, then where is the incentive for them to do good research and to come up with a good textbook? Okay, this is why it is important to ensure that copyright is not violated, and especially being part of the academic community, it is our job to ensure that we protect each other's copyrights as well. Because I mean, tomorrow it could be us. If I write a paper and then somebody takes the benefit of that paper, that would be a huge blow for me. I will be discouraged from writing any other papers in the future. So it is important for us to be aware of where these infringements might take place, and if we unwittingly are also contributing to the infringement of somebody's copyright. I would also like to talk about another case, because I mentioned photocopy, and this case happened as recently as 2016, if I'm not wrong. I think the judgment came in 2016. I'm sure a lot of people have heard about the case as well. This is a case that happened between Delhi School of Economics, Delhi University in general, and the publishers of Oxford University Press, Cambridge University Press, and several others. These are supposed to be the best publishers in the world. But I'm sure you also know that their books are super expensive, extremely expensive. And it's also for a particular reason, because the authors are really good authors. They put in a lot of work. And also Oxford, Cambridge, etc. They try to make a huge profit margin, right? So they were selling a set of very good books, and in Delhi School of Economics, their curriculum prescribed those books, but not the entire books. They prescribed certain excerpts from each of these super expensive books by Oxford University Press, Cambridge University Press, etc. Now, these students who went to Delhi School of Economics could not afford to buy all of these books. So naturally, what happened was that one student would take these books, go to the photocopier shop. There is a photocopier shop called Rameshwari Photocopier Shop. And this is inside the Delhi University campus. So it is a licensed photocopy shop which is inside the Delhi University campus. So they would take their books to this shop and they would say that from this page to this page, I need a photocopy. From that page to that page of the other book, I need a photocopy. So the owner of this shop realized that every year students want the same set of photocopies from different books. He was a clever man. He decided that he would keep these photocopies in advance. He would make it a pack because for a particular curriculum, they need all of these photocopies. He took out photocopies from different books, made them into one book, and started selling out the photocopies. Now, this became a very controversial case because when Oxford University found out, they naturally brought a suit against them. And the photocopy shop was shut down immediately and, everything was seized. But the point is, does this photocopying fall within educational purposes? The Delhi University argued it does. But the law actually works in strange ways. The wording that is used in the act is a little complicated. The wording used is if any reproduction of copyright work is done in the course of instruction by a student or a teacher. Okay, so what it means is if you reproduce a work, you as a teacher or you as a pupil, if you reproduce a work in the course of instruction. The most debated part became, does in the course of instruction mean only within the classroom or outside of the classroom as well? Because the photocopying is not happening within the classroom. It is happening outside, maybe within the campus, but not within the classroom. So then the question came as to what is in the course of instruction, and several arguments were made by both parties, but eventually the court held that even if these course packs are being sold separately, they are not competing with the original author. Okay, because the students were not going to buy those books anyway. They were extremely expensive books. These students were not going to buy those books anyway. What was ultimately happening was knowledge was being kept away from them. So the court said that even though it is being photocopied, of course, the teacher is not involved here at all. Competition between the photocopy shop and Oxford University Press or Cambridge University Press. And therefore, photocopying of somebody's copyrighted work would still fall within the meaning of fair use. And they said that course of instruction does not limit itself within the classroom. And now more than ever, we know that course of instruction is not limited to a classroom because we're on our screens trying to communicate to the students, trying to take classes. So naturally, it is not bound to a classroom. Right now, I could download a particular research paper written by somebody and send it across to my students. What I'm basically doing is I'm communicating a work to the public. But because this is not, you cannot say that it has to be limited to a classroom. I am simply doing this in the course of instruction because I need them to read that article to understand the subject matter that I'm teaching. So that is a great thing for us because we are not infringing upon somebody's copyright by using it for our educational purposes and for teaching purposes. Okay, again, research is another reason where you can reproduce. You can take a photocopy of somebody's book. It is only if it is only for the purpose of your research. Okay, that would not amount to an infringement. But if you take a photocopy with the intention of selling it to someone, that is a clear infringement of a copyright, even though you're a teacher. But if you're taking the photocopy with the objective or intention of selling it to someone, that is an infringement of copyright. So I could go on and on about this, but I think I've completed my 1 hour. If there are questions that I can answer, I'd be more than happy to do that.
Yeah, Simona, it was really a very experiential sharing of your cases, and I think it was very beneficial to all the participants. One question we have from a participant: when we apply for a patent, how many days it may take to give us the patent approval?
Okay, so patent filing is a tedious business. I will say that at the outset. There have been reforms trying to simplify the process, but if you ask me for the maximum period, I would say it is 1 year. Okay, so
Okay.
from the date of filing, you have 1 year to file your complete specification, and there are several procedures that will happen after that. There'll be examination of your patent. There'll be advertisement where people oppose or try to cancel your patent, and then also if you can still prove that you have the necessary requisite to get a patent, it'll take at least a year for you to get all of that done.
Okay. There is a request from all the delegates to share the PPT.
Of course,
So,
I'll definitely do that. I'll
yeah,
share it with you. You could probably share
yeah,
it with the
yeah.
rest of them. Yeah.
So along with the certificates, the PPT will also be shared. So this
Yeah,
is for the
definitely.
kind information for all the delegates. So I request Dr. A.K. Mutt, madam, to propose vote of thanks.
Good afternoon to everyone. I deem it a great pleasure to propose the vote of thanks to all who have helped us in making this program such a resounding success. First of all, I would like to propose my hearty vote of thanks to the honorable delegates who blessed us with their presence. I, on behalf of our college, acknowledge my thanks to our distinguished speaker, Professor Simona Wahid, KLE's Law College, Bengaluru, for making excellent presentation and making this program interesting and meaningful. I must mention our deep sense of gratitude to our local governing body chairman and members and our beloved principal, Professor M.B. Kolavi, for their moral support and guidance. I also extend my thanks to our staff for their enormous cooperation in the organization of this event. I would like to thank the convener of this webinar, Dr. Sandhya Kulkarni, and organizing committee. Once again, I extend my big thanks to all who have directly and indirectly extended their hands to make the event successful. Thank you. Thank you, one and all.
Simona, thank you very much.
Thank you.
And I thank all the delegates. Yeah. The feedback link is sent to your WhatsApp group and the Telegram group. Please fill the feedback, and by tomorrow you'll be getting your certificates along with the PPT. Okay. Thank you. Thank you, one and all. Have a nice and a safe day. Thank you.